Welcome to another episode of Finance X Media. Today we have Logan Woodruff with us. He's an estate planning attorney. And today we want to talk about how we can help protect our assets and how we can plan for the future after someone passes away. So I'm trying to envision like a scenario that someone would need an estate.
I think I got this. So, Melanie.
Ooh, Melanie.
She owns 3 nail salons.
Of course.
Has $100,000 in the bank account. But here's the caveat. She's got a husband. They've been fighting. Mm-hmm. He maybe has a girlfriend, kind of separated. Mm-hmm. So she's driving in between her 3 salons. You know, she's a baller.
In her Mercedes.
She's driving in her Mercedes down the road.
Yep.
Boom! Gets hit by a garbage truck. My wife got hit by a garbage truck, by the way. She didn't. She's alive.
Okay.
Yeah.
Cliffhanger.
Yeah. Melanie's gone. How does that work? How does that play out? How messy is this?
Well, in that situation, probably not as messy as you might be thinking. So if they're married, husband and wife, the default statute in Arizona says assets go from one spouse to the other. They're the primary beneficiary. If spouse isn't around, then it goes to the kids. So even if they were fighting or separated, if they're still married, that surviving spouse.
The kids are 18. Throwing it. I mean, they're older. Mm-hmm. Like, are they fighting, contesting?
They could try. I tell clients that in that scenario, you're going to be looking at probate because now we have a deceased person with assets in their name and nobody who has authority to take care of those assets. So the family would go to probate saying, hey, judge, please put me, the surviving husband, in charge of the assets to, take care of everything. And yes, the kids could try and make a claim, but the default is pretty straightforward and clear in Arizona. It's the husband who's the beneficiary.
It doesn't matter if, they're legally still together, but they live in different places. None of that really matters. It's what the paperwork says.
Right. You can afford Netflix for the rest of your life is what it is. Yeah.
Lifetime subscription.
There you go.
I'll take it.
Yeah. So what are the issues at that point? Well, home and auto insurance are going to be the first lines of defense for Melanie. So probably pretty quickly they're going to go through the underlying auto insurance. I recommend to clients to have a good umbrella policy in that situation as well, so that now we've got a much higher limit in place. But I also like umbrella insurance because they have to hire an attorney to represent Melanie if there's a lawsuit. But the other thing about that is if they go through home and auto insurance and the umbrella policy, they can now come after Melanie's assets. So equity in her home, nail salons, cash in the bank account, brokerage accounts, they're all at risk in that type of situation.
And her husband's accounts this time. So that's a revenge she finally gets.
So could they actually access?
Joint? They'd still be joint
assets.
Oh, that's right.
Joint liability.
Okay.
So, Logan, you're obviously knowledgeable. You've been doing this over a decade. How did you get into estate planning? I mean, I know that you're a graduate of ASU Law. What got you down the path of the legal sector?
Yeah, so it was probably more of a roundabout path as compared to most. My background in terms of undergraduate is actually in construction. So I did that for a number of years here in the Valley, large commercial construction. Then went to law school, and that was, after a couple, downturns in the economy. It was just, hey, I wanted to do something else, and very quickly in law school realized I didn't love litigation. There's a lot of people who that's their thing and they like it. I didn't like it. So if you're not doing litigation, it's usually contractual work or estate planning. And luckily enough, right out of law school, I got a job doing estate planning. I'm doing it ever since. So it's been great.
Do you ever run into scenarios where there's like pets? Like I picture a famous, like the puppy chow dog. Like would that dog have an estate plan?
Well, so it's more along the lines of the owner saying, hey, I want to leave, Fido, $10 million so that, Fido can have, right.
There is a Netflix show called Gunther's Estate, and it's the same thing. It was a German dog that got left millions of dollars.
Wow. Well, I'm always telling clients that I'm happy to volunteer as the trustee of Fido's, pet trust, as we call it, because I'll make sure Fido has great Hawaiian vacations, and right.
I'm breeding these chickens with the necks on the last.
Oh yeah, the naked neck chickens.
He could be the trustee for the chickens.
Give it all to the biggest chicken. That's perfect. Well, and I was curious, so, we talked a little bit about what's the difference between probates or the probate process, wills, and trusts? So how do those all play together?
Yeah, so with no planning in place, if you were to pass away, Arizona, like I said, has already written your will. There's default state statutes of where the assets are going to go. But probate is kind of like a lawsuit. It's a forum for people to make claims against your estate. You know, if you had a business deal go wrong 20 years ago, that person can try and make a claim for assets. On top of that, I was talking to a friend of mine who's a litigator, and he was down in Tucson for a week litigating between family members over stuff, right? And family fighting about it. It was like $100,000 in fees. So it can definitely get expensive. It's time consuming. All your affairs are out there in public. So I definitely recommend to clients that they avoid probate if at all possible. Now, next step most people think of is, hey, let's do a will. What does a will do? It takes the place of what state statute says is supposed to happen. So you can say, hey, I don't want to leave it to my husband who I'm fighting with. I want to leave it to my 3 kids or my favorite charity. But a will still has to be submitted to probate. So yes, you get more control, but you're not actually avoiding any of that headache that is probate.
If the husband did it, like he was driving the garbage truck, for example, because it almost always is. It's like a pretty high percentage that it's your spouse that kills you.
That kills you, yes.
And if that's
Yes.
follows the chain of asset distribution, how does that?
So luckily enough in Arizona and most states, there's what's called a slayer statute, meaning if you kill your spouse, you don't get anything. So not in husbands.
Think of everything.
I gotta write that down.
Right. Remember that one, yes.
One person has
Sorry,
to mess
Jody.
it up for everyone.
That's right.
So, but you were asking though, difference between probate, wills, and trusts. Trusts avoid the probate process, and the reason why is you can think of a trust kind of like a legal container into which you transfer your assets during your lifetime. So we'll use your home as the example. If you have a trust, I tell most of my clients here in Arizona, go ahead and we'll do a deed transferring ownership of the home to the trust. The result there is that when you pass away, there's now no assets titled in the name of a deceased person, and therefore no need to go through probate. It's the terms of your trust that says, hey, I want my spouse to step in, or my brother-in-law, whoever it is. They can now control the house, take care of it for the benefit of the kids, and we don't have to go to court to make that happen.
So, Logan, one thing we really like to do in this channel is we like to be very proactive. So our listeners, they kind of know not only what the laws are right now, but where we're heading. So can you give us something that you see kind of on the forefront of what may change in estate planning that kind of dictates how you operate on a day-to-day basis, primarily maybe with high net worth clients?
Yeah, so what most people have been worried about lately is the estate tax exemption amount. Okay, so when we're talking about estate taxes, or what people call the death tax, that applies when you pass away to all of the assets that you own. If your net worth reaches a certain threshold, anything above that threshold is taxed at roughly 40%. So that threshold these days is quite high. Next year it's going to be $13.99 million per person. Okay, so meaning if you have net worth less than that, you can pass everything on to the kids, estate tax free. There are no death taxes that apply. Well, we've gotten to that number based on a series of laws, but big picture, the last law, I'll use this as an example. In 2012 was at 5 million. It was supposed to go up from there with inflation. In 2017, they doubled it from 5 to 10, and that's how we've gotten to the 13.99. So when they doubled it, they didn't have enough votes to make it permanent, and so in 2026, it's supposed to be cut back in half to probably roughly 7 million or so. Clients who are close to that threshold, 14 million per person or 28 million per married couple, if you're below that, you probably don't have much to worry about in terms of estate taxes. But if you're over that, I tell clients, hey, even if it went down to $1 million next year, the planning I do with clients doesn't actually rely on their estate tax exemption amount. So we can turn your taxable estate into a non-taxable estate even if there was no exemption.
And this goes to that point. This isn't so much, this is back to the Melanie scenario. Her net worth, we didn't really play into our scenario. There's a lot of things going on in why you do the trust and will and estate planning. It's not just the taxes.
Oh yeah, most of my clients, when they come to me, they're not coming to me because they have estate tax issues. It's more of, hey, I want to plan for my family. I want to make that transition a lot easier and smoother. But I also want to protect my kids. I don't want to give the dumb kid who doesn't know how to spend money, essentially a loaded weapon with a check, right, to go blow it on the newest.
Peace of mind.
Right.
Yeah. Sure. A voice from the grave.
Right. protect them from their own bad decisions, but also set them up in a way where now that inheritance could be protected long term.
Love it.
And when would you use a revocable trust versus an irrevocable trust?
So revocable trusts are what most people do when they want to put together a plan for their family, right? Revocable in the sense that once you put it in place, you can make changes to it down the road. So in my scenario, I've got 5 kids, by the way. They definitely keep me busy when I'm not doing estate planning. And my oldest is 16. She's not anywhere in any capacity as a decision maker. But let's say 10 years from now, yeah, I could see her being the successor trustee, taking care of things for my wife and I after we're gone. So with a revocable trust, I can put a plan in place now, and I can change it. I can update beneficiaries, trustees, how it's administered, no problem. And so most people who put together a trust are going to do a revocable trust. Irrevocable trusts come into play when you have estate tax issues or you are wanting to have asset protection. And the thought process there is if you put something in an irrevocable trust, it's much harder to change, and therefore in the eyes of the law will give that trust more protection from your creditors.
So we can still be alive and get the benefits of having this shield around our
Yes.
assets, so to speak.
Yes. So it's not just, hey, I'm going to put everything in an irrevocable trust. It's, hey, let's use the right structures, the right entities, LLCs, partnerships, holding companies, all owned through...
Make it miserable to get,
for a plaintiff to try and get those things. But then, yes, either owned by a revocable trust or partially owned by an irrevocable trust.
Not that we want to do anything nefarious.
No.
But it's nice to have those guards there.
You want those barriers, make
Yeah.
it harder to pierce that veil. And
Well, heaven forbid you get in a scenario where your kids do something, and
Yeah, your 16-year-old driver can cause you liability, right? So yeah, I'm talking to clients all the time about, hey, how can we add more layers between you and your assets? How can we bifurcate risk, right? I don't want the risk of one lawsuit being multiplied across multiple properties, multiple businesses or accounts.
or you do something in one business, you don't want that to affect the nail salon, to affect your rental property.
Exactly. Yeah, you don't want to have the nail salon LLC own the rental property because then you're going to have problems there. But it's also a matter of, hey, let's add some more privacy. If you hit somebody on the freeway, I don't want them to know that you have 5 rental properties, right? Or that it's worth their time and effort to come after you personally.
I don't want them to know anything.
it kind of leads me into I get this question, on a daily basis. The state that you set these entities up. We're dealing now with the BOI filing. And so can you touch a little bit on that of, you're an Arizona resident, you live in Arizona, you work in Arizona, everything that you do in Arizona, is it more or less advantageous to start looking at the Wyoming LLCs, Delaware. Or like can you go into the mechanics of how you advise a client?
Right, so this goes into a number of different issues. We'll start first of all with layers. We'll use a rental property as the example. You have a rental property here in Arizona, you're going to want to have an Arizona LLC, just so that you don't have to foreign register an outside LLC to do business here. So you have the Arizona LLC, but when you create an Arizona LLC, most people are going to put their name all over it, which is not good from a privacy perspective. So what I recommend to clients is that they have a holding company that would own the Arizona LLC, and that holding company should afford them privacy. So you're right, there are many jurisdictions, Wyoming, Delaware, Nevada. I'm a big fan of Wyoming, and 3 big reasons. 1, privacy. 2, LLC law was created in Wyoming, so it's really robust and protective of the owners of the LLCs. And then 3 has to do with the cost of maintenance. So in Delaware and Nevada, I've talked to a number of clients who've said that they spend anywhere from $500 to $1,000 a year just to maintain the entity. Filing fees, registered agent fees, etc. My clients pay about $200 for their Wyoming LLC each year. So
Kind of like California, how California
$800 a year, just for a fee.
Yeah.
And then on top of that, you have your corporate
State,
fees.
yeah.
yeah,
See, this goes back to why you want a second identity.
Yeah.
I mean, it all goes into that.
And so does the estate, basically, when there's an estate transfer versus a gift, what is the difference between those 2 things and how they're taxed?
Yeah, so what you're getting at is gift taxes and estate taxes. And here's the idea behind both of those and why they're tied together. So the IRS is worried about the billionaire giving away all their assets during their lifetime and now having nothing left that the IRS can tax. So what the IRS says is, hey, you have an exemption amount, that $14 million that applies at your death, but that also applies during your lifetime. So if you want to gift away $14 million this year, you can do that and no taxes have to be paid. But if now you're gifting above and beyond that amount, well then gift taxes apply, and it's essentially the same as the estate tax. Yeah.
Okay.
I've always been fascinated on the history of like how we got to this point. You know, estate planning goes as far back as, you know, ancient Egypt, Greece, Rome, but then in more modern times, you have the prominent families like the Carnegies, the Rothschilds, and people like that. Can you touch on
break up their estate instead of focusing on this little people? Let's focus on the 50 people that matter, and let's break their estates up.
Can you see, has there been like a drastic change in estate planning, let's call it, over the last, 50 years? Because when we look at tax, from the most part, like if you look at tax code from the 1980s to right now, I mean, there's not a whole lot of new nuances. So do you notice something similar to that, to where at least estate planning is changing with the times, or do you feel like it's still more of a kind of an archaic setup process?
Well, I think a lot of people are realizing the benefit of putting together a plan the right way to give the most protections for the next generation, right? Most of us say, hey, when I'm gone, my wife's gone, we want to leave it to the kids. Yeah, a lot of people do have charitable intent, and that's great, and we can help them with that, but a lot of people want to leave it to the next generation. But how can you do that with the best benefits for them, right? You could do an outright distribution, which is great and easy, and leave assets to them in their checking and savings account. But now that money, if it's commingled with their other income, is at risk in terms of lawsuits, divorces, and creditor issues. Okay? So instead, if you set up your trust the right way to leave assets to the kids in trust, they can still be in charge of their share, but now it's going to be in a structure that if they had a divorce or a lawsuit or a creditor issue, that inheritance is not at risk in those scenarios.
Or a Coke problem. Because honestly, if you leave them all this money, they're going to have a Ferrari. We're going to start doing Coke. Then they're going to hit somebody. Then all those assets are at risk again.
Well, the thing with that is if the car is not owned by the trust, the inheritance is still protected. Right? Yeah, even in the Coke scenario.
So give them the Coke problem. It's okay.
No, no. We're trying to put, so in that scenario, if your kids are making good decisions, you'd want to name a third-party trustee, so they're not buying the Ferrari, they don't have the extra pocket change for the Coke, and they're going to not make those bad decisions that are going to ruin their lives. So getting back to your original question, though, in terms of what's changed over time with the law, yes, estate taxes, when they came into play, have been a big deal. Over the last, I would say, 20 years, estate tax threshold has gone up and down. So there's been changes over, I would say, the last 15 years for the most part. So that's been one of the big issues there. I would say the other big issue has to do with how retirement accounts flow through the trust, right? So in 2020, there were some laws that were passed that prior to 2020, if you inherited a retirement account, you could take money out of that retirement account based on your life expectancy. But now it's you have to take it out in 10 years. And so making sure that your trust is drafted the right way to minimize taxes on that end is really key as well. Yeah.
I'm dealing with that personally for my dad.
So yeah, usually you have to take it all out within 10 years. I tell clients to probably take about 12% a year, so that in year 10 they don't have a huge taxable
So you
estate.
don't get kicked in the pants all at once.
Right.
Slow kicks. Over there.
Don't make jokes right when I drink water.
Nudges.
Boom, all over.
And when you advise that, do you typically work with a CPA tax advisor on strategizing that?
Yeah, I will definitely say talk to your CPA, the expert on all those issues. I can give generalities of what potentially has happened, but you guys see the numbers, and you can give that. So I like to work very closely as a team with the client CPA to make sure that it's not just what some attorney thinks is going to be right, but actually what their CPA is telling them, hey, this is what you should do. So yes.
No I in team.
No.
Remember that.
Yeah.
Yep.
Takes a team to get it all done.
Yeah.
Well, and I was also curious for can you hold just static assets in a trust, or can you also hold income producing assets? So a rental property, dividend stocks, those types of
Bitcoin.
things.
Oh, yeah, all of it. You can own
All
the
of it.
trust.
So literally any type of asset.
Right. So most revocable trusts are what we call grantor trusts, right? So a grantor trust is essentially a disregarded entity for tax purposes. So whether you have it own it in your own name or own it through your trust, it's pretty much the same.
Okay.
We deal with that a ton. I'm pretty sure Satoshi has a irrevocable trust.
Oh yeah,
With all
the
the
creator of
Bitcoin
Bitcoin.
Non-remainder.
Hey, it could get to 100,000
non-charitable.
today, the day we're filming this video. So we'll see.
Boy, I remember just like it was yesterday. It was
All of our
$1,000.
crypto videos. Yeah.
Yeah.
And Nate, I know you had a couple points on buy-sell agreements.
Yeah, so just what I've seen when people are setting up, and a lot of times people haven't set anything up. They don't have wills. They own a business. They're like Melanie with her nail salons, but there's no agreements. You know, maybe Melanie even had a partner in her nail salons with her cheating husband surviving.
There's layers.
Yeah, there's layers that could be in there. None of this is dealt with.
Complexity.
Yeah, so buy-sell agreements.
What I've seen, or what's your opinion on that in dealing with trusts and grantor trusts and doing that all at once with a business?
So yes, I would definitely recommend getting an overall plan in place. Yes, you want to have the right LLCs in place. You want to have the right membership interest being owned, whether it be the trust or the holding company. Are we wanting to get privacy, or are we worried about lawsuits? How better to structure those businesses and those assets so that in the event that you hit Melanie, or Melanie, hits Jaron, right? Melanie's, $1 million brokerage account is not going to be at risk in that type of a situation. So they're going to have, Jaron is still going to be compensated because there's going to be good umbrella insurance in place.
In this
Netflix.
case, we want to pierce Melanie's veil, though.
The
We want to
corporate
get
veil.
as much.
Unless Melanie is my client, then no.
Yeah.
Don't
No,
be
preferably
maybe
no.
we'll put a link for a GoFundMe account for Jared.
There we go. There
Yeah.
we go.
Jared. Jared in the
Poor
closet
Jared.
sleep.
So I can get prosthetic arms and legs would be nice.
Neuralink.
So getting back to your question, yeah, you want to make sure you have all that in place. And then yes, when you have partners, talk to your CPA about getting the right structure in place for buyouts. You usually want to document that with the buy-sell agreements. And the thought there is, well, what if your partner gets divorced and now their half interest is owned by the spouse that's divorced? You don't want to have them as
He
a...
didn't like her, so you're not going to like her as a partner either.
Right. Right. So what triggers the buyout of somebody's interest, right? So those buy-sell agreements come in really handy in those scenarios.
And what about charitable remainder trusts? If
I
a
like
client
these.
comes to you, what's your thoughts on that?
So most people these days are talking about charitable remainder trusts when they're wanting to reduce their overall tax liability when selling a business or selling different assets. And so what I tell clients is, yes, that is a definite strategy, but the charitable intent has to be there. It's not really going to be worth your while to do the planning with me and all of this other stuff if you don't actually want money to go to the charity.
Right.
So if you don't like the charity, but you're doing it as a facade, like a tax shelter, it's not going to benefit you
No,
in the end.
no.
Like if you're trying to save the three-legged frogs in South California as a facade to
Right,
pay
right.
taxes.
And I think this is, as you were talking, we have some actual, real scenarios like that. And a lot of times I have clients come to me where, they're describing what the situation is. And as they're describing it, I'm thinking, you're coming 2 years too late. And
They almost always are.
I've noticed
After Jaren's got no arms and legs, they're like, hey, we want to do some
They're like,
tax
look,
planning and some estate
Let's
And asset protection, right.
Across the table.
Right. Well, so if it was Melanie that hit Jaron and she's coming to me saying, "Hey, I just hit Jaron. What can I do to
What
protect
can
my
I do?"
asset?"
I could use a hand with my.
Liquidate everything, put it on you, move out of the country.
No, not tax advice, not legal advice. I tell clients a scenario like that is kind of like saying, "Hey, my house is on fire. Will you sell me fire insurance?" Right? No, it's not gonna. You got to have the planning in place ahead of
Deal
time.
for the right price.
No.
Also no.
Also no. So yes, you got to have that planning done 2 years ahead of time prior to the sale. You got to have the asset protection done before Jaron gets hit, and done the right way, so you really have peace of mind.
And I use 2 years as just, kind of a subjective. Is there a time where, again, we have clients that they're doing very well.
3 years you want it for a trust?
You should have the trust in place for 3 years.
Okay, well, let's talk about that. So a revocable trust, what most people with no estate tax issues when they put it together, a revocable trust does a lot of great things. Helps you avoid probate, helps you avoid incapacity issues, can protect your kids when you're gone. But for you, a revocable trust does not provide any additional asset protection, right? So you hit Jerem when he's walking across the street and you just have a trust. It's the same as if you have all of your assets in your personal name. So when I'm talking to clients about asset protection, I'm talking more net worth insurance, right? What can you do to put yourself in a better scenario to protect all of your assets? Yes, I recommend all my clients, especially high net worth, that they have a family trust. But on top of that, you need the right layers that the trust owns beneath in terms of holding companies and LLCs for rental properties and the LLC for the brokerage accounts, so that everything else is going to be protected underneath of the family trust. Now, for the clients who do have the estate tax issues, yes, we will be implementing irrevocable trusts while they're alive. And yes, that does add another layer of asset protection. But yeah, your net worth has to be up there and has to make sense because it can get expensive.
Or you're a really bad driver, and it's like, I kind of had to put this in coach.
Just because.
Sorry.
I was gonna say, it reminds me a lot of when clients come to us and they're like, I bought this truck, it's gonna help me with my business because it's a tax write-off. But if you didn't need a truck, ultimately that was a bad decision. Like, you need to need it
We're not
first.
saying that specifically to people, by the way. It's just.
It's true.
Right.
But it's true. Yeah, I mean, like I said, more real life scenarios. I have clients that they're gearing up for an exit, and I think that is where the charitable remainder trust can really be super effective, and it's getting them established now. So
Right.
you're showing a root cause of establishing that, because you're basically having this nonprofit active, established,
Yeah.
and in the community doing things. But then 5 years down the road, when you do exit, that trust or that nonprofit or whatever you're doing to try to mitigate those taxes, it already has that history. And I think that is what I see clients not doing.
Yeah.
So would you recommend it's a 2-year process, 3-year process, or
I mean, you're getting into discounting and transferring assets and all kinds of things.
Yeah. When the closing is on Friday and they're in your office on Monday saying, hey, what can I do now? You're exactly right. They're too late. I would say you want at least about a year in advance to be able to do the right valuations, the right transfer, the documentation of that, and have history in there so it's not just a sham transaction.
let's get it all done in 30 days? And
Right.
Yeah. No, I'm with you.
Well, and I know like some people won't want to go start the process just because it can be expensive, it can be complicated, there's a lot of unknowns. What would you say to people who are like, I just don't really want to start the process? What would be your words of advice?
Well, that's kind of like saying I don't want to put on my seatbelt. I might get hit, right?
I said the same thing
right?
for my colonoscopy. Like, I don't want to start the process. I don't want something about it.
Right. Right. It's hard. So what I try and do is I try and make the process really simple, right? It's a lot about education, helping clients understand, hey, here's where you're at. Here's where you want to be. Here's how we can get there, right? It's not, I don't like to use a lot of legal jargon or make it overly complicated, but hey, let's break it down. Let's put together a plan that's going to be easy for you. Yeah, there might be some steps to get there, but I would say as well, when you're talking about doing no planning and that result being your family has hundreds of thousands of dollars of litigation, doing an estate plan of anywhere from $4,000 to $6,000 is going to be pennies on the dollar compared to what it could be in terms of cost.
And all the bad blood that goes with it.
Yeah.
Like, if you spelled it all out, then they don't get a fight about it, the worthless little
Yeah.
crybabies after the fact.
They get to
And they
enjoy
all
their
do.
life. Yeah.
Every time somebody passes away, there's fighting and drama.
And it
You wanna
reduces
spell out
drama.
as much as
Yeah.
possible.
Yep.
The bad parts, the good parts, everything in between.
Is there anything that you'd like to cover today that we did not cover that would be helpful to people are looking into this?
Right. No, I was going to say along the lines of that last question you asked. I would recommend that most people just get the right education. When I talk to clients, we do free consultations, and if they hate me and they never want to see me again, that's not a problem, right? But at least they've got an idea of where they're at and, hey, where you need to be, here's some of the steps. And so
We'll put a link in the description to book that free consultation with Logan.
And he's one garbage truck away from problem solved.
Yep. So thank you for tuning in to another episode of the Finance X Media podcast. We've really enjoyed our time with Logan today.
Thanks, Logan.
And-
We appreciate it.
Yeah.
Thanks for having me. It's
Yep.
been a pleasure.
Thanks,
Yep.
brother. Sorry about these guys.
And tune in to next week's episode.
Cool.
Finance X Media out.